Thursday, the 6th of April in the very interesting year of 2023. That means it's time for another Legal with Liles, Parker. And I am once again joined by Robert Liles and Ashley Morgan of Liles Parker. Thank you so much for being here today, both of you.
Thanks for having
Glad
us.
to be here. Glad to be here, Sean.
And to each and every single one of you, thank you so much for tuning in, logging on, and just hanging out with us for a little while. And thank you so much for the continued viewership and the nominations. Our podcast, we were just notified, was nominated for Best Podcast of the Year in Business for a People's Choice Award once again this year. Again, whether we win, lose, or draw, it doesn't matter. It's just an honor to be recognized by all of you. So thank you so much for that. All right. We're going to get right into this today because we have a fantastic program where we're going to be talking about the Unified Program Integrity Contractors. I like to refer to them as the contracted bounty hunters for the Centers for Medicare and Medicaid Services. And I know some folks don't like me to use the term bounty hunter, but that's what they are. Their sole focus in life is to investigate healthcare organizations to find flaws in your billing, in your coding, in your documentation, and to claw back money. So I said it quite crudely, but I think all of our listeners have come to expect that from me from time to time when we start talking about these interagencies, these government contractors. But that's the truth. So I think what we're going to do is have somebody who's much more eloquent start the conversation by talking about what are the traditional roles of the UPICs. And Robert, I would go to you, but I said somebody who's more eloquent. So I want to start with Ashley.
Sure. So, thank you, Sean. The traditional roles of
I love you, Robert.
traditional roles of the UPIC. A UPIC is a Unified Program Integrity Contractor. So their purpose, as you stated, Sean, is to conduct reviews of healthcare providers to ensure that the healthcare providers' documentation meets the requirements for coverage and payment, and they also are fraud investigators. So their purpose is to make sure that they're ferreting out potential problems of fraud or misrepresentations of the services that are being billed. They will look for aberrances in data and billing. And if they see an outlier or they see a provider who's billing differently than their peers, then they will flag that provider, request documentation from them, and review it to see if in fact the documentation meets the requirements for coverage and payment, if the services are being provided as they're being billed. And if not, they will either request money back or they will conduct a deeper investigation. And they have several different avenues that they can take from there, which I'm sure we're going to talk about, based on what they find from an initial review.
So one of the things, and I get this a lot, and Robert or Ashley, either one of you that wants to take this, when it comes to a prepayment review, what rights does a provider have to request extensions for submitting records? Because I think there's a lot of misperceptions and folks don't understand that there are significant differences between the pre and post payment audit process.
Yeah, for prepayment review, there's not a lot of room for extensions. You get an ADR and you need to submit documentation within 45 days or they're going to deny the claim. And that's going to go against your error rate. There's not a lot of room for discretion there.
Yeah, that's spot on. I have a lot of folks that say to me, Sean, I'm getting a prepayment review, but I don't know that I could produce the records in 45 days. Can you get me an extension? And I have to explain to them that unfortunately, under the program integrity manual, there are no extensions granted for a prepayment review. You have to submit the documentation. So, that's one of the disadvantages of going through a prepayment review. But that should serve as a stark reminder, Robert, if I go to you for a second, on the critical importance of completing your documentation in a timely manner and closing your notes within 24 to 48 hours or as soon as practical following that visit, right?
Absolutely, because the UPICs are looking for little things like that. We've had cases where they came in and they denied the claims solely on the basis that the notes were never closed out, and therefore they said they didn't have a valid signature.
That's right.
And, again, you mentioned, Ashley, the ability to revoke a provider's billing number. We talked all about revocations on our very first episode.
Mm-hmm.
And while you have, as an organization, Liles Parker, you've had significant success with overturning revocations of providers' billing numbers, it's still a protracted legal battle.
Mm-hmm.
It's very expensive, and it's not something that we want providers to go through, right?
No, absolutely not. I mean, if you're revoked, you're not making any money off of Medicare. You're not providing services to any Medicare patients during that time period. And hopefully you've got other streams of revenue that you can survive.
And in many respects, a revocation is worse than an exclusion, because most exclusions, even if it's based on a criminal conviction, the OIG is going to start out with the basics of 5 years for a felony. These days, in a revocation action, CMS is going after 10 years in many of the cases.
Mm-hmm.
It's brutal.
It really
is brutal. And, the thing that I try to explain to people, although, and I'm not going to get political in any way, shape, or form, but, the healthcare system is opposite. It's the polar opposite of our judicial system, right? Which in the judicial system, you're innocent until proven guilty, either, by a jury of your peers or by a judge. And the healthcare system, because it's a pay and chase model, you're guilty until you can prove yourself innocent.
That's
so,
true.
Mm-hmm.
So that brings me to another question that I have for you. So, Robert, when we talk about the authority or the discretion that a UPIC has to make referrals for law enforcement, what does that entail? Who do they typically make those referrals to?
Sure.
And how far can it go?
Well, and let's back up just 1 second. Ashley gave a great overview of what a UPIC is, but it's important to remember that these are fraud fighters.
Mm-hmm.
They are program integrity contractors, okay? They are not out there doing run-of-the-mill audits, okay? You can get those from possibly from directly from the MAC itself. And there are other CMS contractors who will do just a regular run-of-the-mill audit, a CERT audit, for instance, or even a random ADR that is generated by the MAC directly. So you have to keep in mind that the purpose of the UPIC program is to identify and ferret out fraud. And when they send you a request, it's not because it's been a randomly generated list of names. There are no random audits. And in fact, the program integrity manual even says that they don't even have the authority to initiate random audits without CMS approval, okay? All of the audits that the UPICs come up with are based on something. Most of them are based on data mining, which Ashley also talked about, okay? There's something about you're billing impossible days, your RVUs are just through the roof. You've got 4 providers there with NPIs, but for some reason, none of them are having any services billed under their Medicare number. They're all going under one. There's a reason why. So when the UPIC goes in and conducts these audits, and I call it an audit, but as you've pointed out before, Sean, they're not really audits, they're investigations. And when they find something, and they will find something because nobody's perfect, then they have to decide, okay, well, is this a problem that really rises to the level of civil or criminal culpability, or is this an administrative matter?
Mm-hmm.
If it's an administrative matter, depending on the nature of the allegations, they may just do a broader audit and try to extrapolate damages and go after money that way on the post-payment side. If it's something more serious, they can go to CMS and recommend that a suspension action be taken. And just so you know, they actually do go to CMS. I mean, there's a lot of folks that say there's no way they could have gone, how did they get that approval? No, well, we've gotten a lot of interesting documents over the years, and they do go to CMS. They do what they're supposed to do. There's a question about how much time CMS actually looks at it, perhaps, but they do go to see. But the point though is, if there's something else there, something that is a credible allegation of fraud, or possibly even clear allegations of fraud. For instance, they love to go out and do beneficiary interviews, and if the beneficiary says, "I got $50 to refer other members of my family to this provider," they will make a referral to OIG and or to DOJ. And those are the two primary agencies when it comes to law enforcement that they send them to. They can send them also to the state MFUCU, and MFUCU, Medicaid Fraud Control Unit. First time I heard it, I thought they were disrespecting my mother. So they can make referrals to the state. But the UPICs and Ashley is currently working on, in fact, several UPIC audits of traditional Medicaid claims. Now, a traditional Medicaid claim, Sean, these days is like a unicorn.
That's right.
Why don't you kind of explain what I mean by that, Ashley? But traditional versus managed care.
Yeah. So there's two different avenues where you can have coverage. You can either have coverage through the state, like for example, in California, the state Medicaid program is called Medi-Cal. That's their traditional fee-for-service Medicaid program, just like Medicare Part B or Medicare Part A fee for service. But then there's also an Advantage plan, which many, I think we saw a statistic that was 83% of Medicaid patients are on an Advantage plan as opposed to fee for service. Right. So then that's going to be essentially a private insurance company that's administering that program. So it's going to be, potentially a Blue Cross Blue Shield or some other sort of line of business from a private payer that's going to actually be administering that program, and they are responsible for doing their own audits on those claims, very similar to Medicare Advantage, where Medicare Advantage is responsible for auditing their own claims and taking back money that they don't think may have been properly done, or doing their own fraud investigation, as opposed to the UPIC doing it on behalf of CMS for a traditional Medicare claim.
Now that's significant. She said 83%. Medicaid managed care. Right now it's sitting at 61% for Medicare Advantage. This is what we've talked about for years, Sean. You and I went over that document. It's not a secret document, but it makes it pretty clear. Right. CMS wants out of the healthcare business. I mean, absolutely, they don't want to be administering traditional plans any longer. They are really pushing hard for this to go the managed care, the Advantage plan route.
And I will tell you, I have an 82-year-old mother, and she constantly calls me and says, "I just saw Joe Namath on TV," or "I just saw JJ Walker from Good Times on TV," and they wouldn't lie to me. They said that I can get free rides to the doctor, or I could get free meals delivered to me, or I can get free this or free that. And I have to explain to her, they're lying to you. You get nothing for free. They're not going to give you free rides anywhere. You're not an invalid. You're not in a wheelchair. They're not going to bring you free meals. You don't qualify for free meals. Okay? These things that they are telling you are free, there are strings attached. You are staying on traditional Medicare, and you are keeping your GAP plan, because that ensures that if you need emergent care or you need any kind of care at all, you don't have to go through a gatekeeper to get it. Yeah. And you're covered. So, I have an uncle, my mother's brother, he had to go to a Medicare managed care plan because it was cheaper. He's one of these folks that, didn't prepare well for his later years in life. And as a result, he took early retirement, which completely decimated what he should have been getting for retirement from Social Security. And as a result, he has to go to a plan that is substandard. And that's the reality, the grave reality that a significant portion of our seniors are facing. I mean, think about how many seniors are on Medicare, Medicaid. Talk about a double whammy.
Yeah.
Mm-hmm.
But
right.
to kind of bring it back to UPICs for a second, there is nothing that prevents UPICs from auditing the managed care claims. But the question comes up in my mind,
That's right.
Who's going to pay them?
Mm-hmm.
Not CMS, because they don't have a dog in that fight at this point. It's a capitation program. The Advantage plans have to make it work. But I can see how the UPICs, if I were at a UPIC right now, I'd be losing a little bit of sleep, because every year the traditional plans are getting smaller and smaller. And that's where they have, 85% of their audits last year, I believe, were focused on the Medicare side. They did 14 or so percent Medicaid, and just a smidgen of Advantage work. Okay. But I see in the future, I see the UPICs working for the SIUs, because, all right, so that who's doing the audits of the managed care? The SIUs. Every one of these Advantage plans and managed care plans have a special investigations unit, and those guys are going to, the UPICs, they're private companies, just like your friends at Advice, and they're probably, I could easily see the SIUs using them in the future to contract out and do their investigations and audits. But that raises an interesting issue. You and I have been doing this a long time, and so has Ashley. And we represent a lot of providers in the Medicare administrative appeals process. Mm-hmm. And we've got a lot of criticisms of the process, but frankly, in the grand scheme of things, it's a pretty good process. They get behind. There's all kinds of problems with it, but at least it's a process. You compare that with the rights, your appeal rights against an Advantage plan, a Medicare or a Medicaid managed care plan. Oh my gosh. Mm-hmm. That's the Wild West.
I had a provider say to me the other day, and we got into this discussion. He said to me the other day, I don't want to participate with Medicare anymore. They're a pain in the butt. And, I said to him, listen, for as bad as you think Medicare is, I would rather deal with Medicare every day of the week and twice on Sundays, because they are the only one with a defined appeals process.
Mm-hmm. Thank you.
I agree.
Yes, and the private payers are just as bad as managed care. They have SIUs too. They make up the rules as they go along.
That's right.
It's really tough. So I guess what I'm saying is, providers need to understand this is going to get rougher in the future, not easier.
Yeah.
Because they don't have the same appeal rights with managed care and Advantage claims as they do with traditional Medicare and Medicaid.
I have people ask me all the time, why is there such a shortage of physicians at this point? Why is there such a shortage of individuals going into medical schools? They did away with the requirement to take an MCAT. I mean, listen, you could have a 1.0 GPA in high school and you can still go to medical school. I mean, the old joke is, what do you call the person who graduated at the bottom of their medical class? Doctor.
Right. Mm-hmm.
Well,
and the other problem that we have are all of these doctors or all these students that are coming here on these, H-1 visas, right? They're going to medical school, and as soon as they graduate, they're taking their $250,000 education, and they're going back home to where, they're providing services there. That's depleting our system as well.
Mm-hmm.
Anyways, that's a conversation for another day. And
go ahead. The point though is the UPICs, they have a very interesting role today. I think that role is going to have to change in the future. But there are a few things that I'd like for Ashley to kind of touch upon, because one of the things that we've seen just in the last couple of years, and Sean, I know that you've been personally involved in it, has been the expansion of the collateral impact matters that are coming out of these UPIC audits. The UPIC does an audit, they come up with an overpayment. Next thing you know, referrals are made to everybody and their brother. Ashley, can you kind of talk about because you've been working on a number of these cases around the country?
Yeah, absolutely. So what we've been seeing happen is the UPICs are being extremely aggressive, just plain for Medicare. They will, do an initial review. Then if they don't like what they see, they will put a provider on suspension. They'll put them, they can put them on suspension, prepayment review, and do a statistically valid random sample extrapolation audit all at the same time. And then in the meantime, while they're doing their review, we've seen them communicate with the state and say, hey, state Medicaid office, we put this provider on suspension. We're doing a fraud investigation. You need to take similar action. And we've seen where if states don't have the ability to place a provider on suspension, to suspend their payments or take up some other sort of action, then they're terminating the provider. Because they say we don't know how to turn their payments off, so we just have to terminate your number. And once you work out your situation with Medicare, we can talk, but you've got to deal with that. And we've also seen them communicating with the OIG and saying, "Hey, OIG, here's our findings. Are you interested in this matter?" And we will see that back and forth in their advanced case track systems when we are going through the appeals process. We get that documentation back sometimes. So you have a provider who's not getting paid for Medicare, who's not getting paid for Medicaid, and they're also in the process of trying to submit payments for every single claim. If they're on prepayment review, they've got to submit documentation for every single claim before that'll get paid. But if they're on suspension, then that's going into an escrow account. And then hopefully in 6 months, they're getting their audit results back, and hopefully they're getting that suspension lifted if you can survive during that 6-month period. And if you are not seeing movement within 6 months, then we know that they're probably talking to the OIG or to the Department of Justice about a further fraud investigation, potentially a civil action against the provider.
And that termination action that Medicaid took, by the way, that's an adverse action.
Mm-hmm.
And
that's right. It is an adverse action.
That's something that has
severe consequences.
Every private payer. And then all of a sudden, we see all these private payers ganging up on the providers saying, well, wait a minute, if Medicaid didn't want them taking care of their patients, I'm not sure if we want them taking care of ours.
That's right. That's right. Because they'll report it to the MPDB, and then that gets reviewed there.
And then, of course, they'll talk about the state matters and the societies. Talk about that, Ashley.
Sorry, say that again.
Robert, I'm going to turn. This is going to become the Robert Liles show, man. Go ahead, take it over. I'm going to mute myself.
Oh, it's just Ashley has seen these cases. It's just a snowball effect.
Mm-hmm.
No, it is. And listen, I don't think a segment of the providers and the listeners out there truly understand just how powerful and how far-reaching a UPIC, their tentacles can reach. Mm-hmm. Let's actually talk about their ability to make a referral to a medical board.
Sure. So actually, under the program integrity manual, UPICs are required to make a referral to a provider state licensing board if they think that the provider engaged in instances of unethical or improper practices or unprofessional conduct. So, and we've had cases where a UPIC has made referrals to state licensing boards. We've seen it if they think that a provider has failed to exercise the proper level of supervision over a nurse practitioner, for example, if they're billing, services incident 2, and they don't think that the provider's not even incident 2. If they're under their supervision.
But that's a great point, Ashley. Incident 2 is a huge issue, right? Because the supervision of a nurse practitioner. How are you supervising a nurse practitioner if you're out of the country?
Exactly. And we see that a lot because, to bill incident 2, you have to provide direct supervision, which, we do have arguments under the public health emergency about that. But prior to the public health emergency, and the public health emergency is ending any day. So, you need to be immediately available in the office to be able to provide direct supervision to qualify for incident 2. So if you're in a different office, an hour down the road, and you're billing your nurse practitioner incident 2, that's not going to cut it. And they're going to see that you're billing multiple claims on that date, or they'll find out that you were on vacation in another country. And that's a big deal. They will report that to your state licensing board, and you're going to have to answer your state licensing board, in addition to potential fraud investigations from the Department of Justice.
Robert, you and I had a case with a provider in the northwest part of a state, and I won't go any further than that, where, that provider's story kept changing to you and I, right? We kept getting all kinds of different, explanations. And the Office of Inspector General wanted to bring this provider in for a Q&A. And, you were able to successfully keep him from having to go in to have a conversation, but it was tied directly back to what Ashley was just talking about. How are you supervising somebody when you're in the Middle East or you're in Europe or you're in the Caribbean?
Well, I mean, you're an expert on, a true expert, one that testifies on Incident to and shared services. You know what you and I have been preaching for many years now. It's been more than 30 years since they first initiated Incident to, and doctors still aren't getting it done correctly. I really think that it's not worth the 15%. I know they think that it is, but it's not, because all it takes is one audit, and any money that you ever made from that 15% is going to be gobbled up.
Yep. So I do want to point out, because I know I have a lot of folks that are always asking for specific citations to information that I give or our guests give. So Ashley, when you're talking about the Medicare Program Integrity Manual, and you're talking about the fact that there's specific guidance that's available to the UPICs, what chapter, what subsection can people go to actually identify where this information is that we're talking about?
I would look at section 4 of chapter 4. I'm sorry, chapter 4 of the Program Integrity Manual. That's going to have all of your provisions there on what actions the UPIC is able to take. That's where I would start.
Right, chapter 4, and very specifically, you could go to 4.9.4.1, which is the specific citation in chapter 4, where you can find UPIC referrals to medical boards. But they also have the ability to make referrals to professional societies, right? So what would be the difference between, we have a lot of people entering into the healthcare industry on a daily basis who don't understand what's the difference between a medical board and a specialty society. How do they differ? What would be the difference between those for the layperson?
So a professional society is going to be more like, for example, an anesthesiology society that governs and provides guidance to anesthesiologists. Is going to be like a specialty group, as opposed to a state board that oversees all of the medical doctors in a state. I don't know if you want to expand on that, Robert.
No, I think that's a pretty good overview of it. It's a private, typically not-for-profit organization that is organized by specialty groups to establish the standard of care, really, that they think that their industry has. And there's many in the areas of rheumatology, oncology, anesthesiology, and at some point someone may be a fellow in one of these. Well, believe it or not, and frankly, it's not that different than AAPC for coders, because I've actually represented people who AAPC wanted to pull their ticket, if you will, for their membership. And luckily we were able to talk them out of it. But it's the same thing on this side. If every one of these professional societies, they have basically it's not a medical practice act, but it is kind of a professional conduct provision that they adhere to. And if the UPIC were to submit evidence to them that a provider has engaged in fraud or other unprofessional conduct, these professional societies then turn around and decide whether or not they want to have a board review to see if that person really deserves to remain a bona fide member of the society.
Yep. So I want to talk about another entity that is not very well known. It doesn't get a whole lot of play, and it's called the National Benefit Integrity Medicare Drug Integrity Contract, the NBI Medic. And this one's kind of interesting because you have a UPIC who also serves as the oversight for the NBI Medic, if you will. Robert, you want to You want to talk about this one for a little bit?
Sure. The NBI medic, their job is to really deal with the drugs, the controlled substances. And I believe Clarent has the current contract as the NBI medic, and they go out and they do all kinds of audits on their own. I've actually represented a nurse practitioner who was audited by the NBI medic because she was alleged to have improperly prescribed certain medications to a patient. So those types of allegations, a lot of times they turn over those types of allegations, especially anything involving controlled substances, to the NBI medic to conduct the audit. So it's another flavor of a UPIC audit or UPIC investigation,
Right.
really.
And this one is tied directly, as you said, to the prescriber and their
Yes,
state
exactly.
licensure, if you will.
Yeah,
right?
and the
I'm wondering-
NBI medic, when they come up with those results, they almost always turn it over to the state medical board, and then all of a sudden the state medical board opens their own investigation.
Does the DEA ever get involved in these as well?
They could, but they haven't in the cases that I've had.
Okay.
And it very well could be that. But you have to figure if they find something that's a very good question, Sean, because we talked about how the UPICs normally make referrals to OIG and DOJ. Right. The NBI medic, I'm sure if they're going through and conducting an investigation and they come up with some kind of nefarious conduct that looks like it's a violation of the Controlled Substances Act and it's more than just bad doctrine, I could easily see them making a referral to DEA.
Yeah. I just, it's a never ending list of acronyms that can come out of the woodwork at any given time to investigate and to add to the layer of frustration, the financial burden that a practice or a provider has to face to fight, to defend themselves. It's just another layer. So it brings me to the last part of our conversation that I want to have today, because we've talked about the investigations. We've talked about the reporting to OIG, DOJ. We've talked about revocations. We've talked about suspensions. We've talked about, the NBI medics. So that naturally takes me to, okay, so you've been investigated and determined by a UPIC to have an overpayment. What remedy do you have? How can you challenge the findings from the UPIC?
So your remedy would be to go through the administrative appeals process. I mean, my initial recommendation is if you receive a letter from a UPIC requesting documentation, don't just send in the charts. You should.
Great advice.
I would recommend that you reach out to counsel, you reach out to a consultant or somebody who has knowledge about what the requirements are for coverage and payment, and that you review those charts, make sure you have everything that the UPIC is requesting. Don't forget to provide documentation, because you're going to get denied for not providing the requested documentation. Make sure it's organized. We, try to attack these claims at the outset, and we prepare what we call, a claim summary in advance and outline what the requirements are for coverage and payment. And we outline where in that medical record documentation those requirements are met, because you want to put up a really strong initial impression against the UPIC, because like I said, they have a lot of power. You don't want to just throw in your charts for 10 patients and then in 60 days you get a suspension notice, because that's what can happen. If they think that there's really something wrong, that's what can happen. They can put you on suspension and request more records. So you want to put in a strong first effort. If you do get a letter back requesting an overpayment, whether it's in connection with a probe sample or whether it's in connection with a larger statistically valid random sample, then you do have an opportunity to appeal through the administrative appeals process. There's a couple different timelines for that, depending on recoupment. You have 120 days to submit that first request for redetermination. If you have a huge overpayment that you're concerned you're not going to be able to pay back, you can't afford to have them recoup all your payments, you can appeal within 30 days, which will prevent them from recouping. But you have to keep in mind, the last demand letter I saw, the interest rate right now for an overpayment is 11.25%. So that interest is
Oh,
going
yeah.
to be accruing the entire time you're in the administrative appeals process.
Well, I want
And
to put something up on the screen real quick. So
go ahead.
let me share this real quick. Because I have a lot of folks that have said to me, can you actually prevail at a UPIC? And yesterday, I had an opportunity to present for the National Alliance of Medical Auditing Specialists. And the title of the program was called You Received the Letter. Now what? And this is an example of a unified program integrity contractor that put a demand onto a client of mine last year for $1.6 million, over $1.6 million. And we were able to fight them, and we were able to get them to rescind the demand of $1.6 million. Now, this doesn't happen every day. The stars have to align. You've got to have some good juju going on, and you got to say your whatever you believe in, your Hail Marys, your prayers, whatever it may be. But this is, to Ashley's point, if you prepare these summaries, if you do your diligence and you're able to push back, and the program integrity manual inside and out to call into question the decisions, the determinations that are being made by the UPIC, they have no choice but to consider rescinding something like this demand, because the last thing they want is this going to the Centers for Medicare or Medicaid Services showing how fatally flawed. And, they want this thing to be resolved quickly, believe me, because they don't want to have to answer to CMS on why it's happening. But this is proof that if you get strong counsel, you can actually prevail in these types of matters. All right. Sorry about that, Ashley. I just thought we would share that, but let me turn it back over to you.
Yeah, absolutely. And that's right, Sean. I mean, you can prevail if you are, taking the appropriate steps to make sure that you're meeting the coverage requirements. And if you do end up with a big overpayment, you take it through the appeals process, you do that redetermination appeal. But it's important too, because you do have some additional levels of appeal after that. There's a reconsideration appeal, and there's also, an administrative law judge hearing. But it's important to be proactive because, and Robert, I'll let you talk about this, but the percentages of favorable decisions that we see coming out from the administrative law judges is significantly lower than it was 10 years ago. Robert, do you want to talk about that a little bit?
It really is a different world. And the numbers 10 years ago were a lot lower than when Sean and I started doing these 20 years ago. Right now, I believe the statistics are that the chances of you winning a case, every claim in the case, is most recently, I think the number is like 28%. Mm-hmm. Well, if that's the situation, I mean, you got a problem. Now, if you add up all the claims that are looked at by the Office of Medicare Hearings and Appeals, only 13% of those were adjudicated favorable last year. 13%. And that really kind of plays into what Ashley was saying and you were saying, Sean. You have to put your best foot forward on day one. Don't think that you're going to get this resolved at the ALJ, because statistically you're not.
Mm-hmm. No. And what's even more interesting, the statistics you guys sent over to me are really fascinating. For partially favorable appeals, it's only 2.9%. And for partially favorable claims is only 19%. So it shows you that the deck is stacked against you at the administrative law judge level. I mean, think about this. OMA just recently cleared a 10-year backlog, right? They had more than 750,000 claims pending at OMA. Mm-hmm. Now, they are not right now going beyond the 90-day threshold that they have to adjudicate claims. And some people may say, well, that's a good thing, right, Sean? No, it's not. I don't think it's a good thing, because I think when they have to rush through these decisions, given the number of appeals that are filed on a daily basis, things get overlooked. Half-assed jobs get performed, or there's a delegation to an attorney adjudicator who may not understand Medicare regulations to the degree that a judge does, or a judge at OMA just might be delegating their review responsibilities, especially if you're submitting on the review or on the record reviews, to their underlings, who then do their own independent research, file an interpretative, ruling, and ignore, anything that may have been submitted. Because remember, an administrative law judge hearing is a de novo hearing. That means that they are not bound to any precedent. They are not bound to any prior administrative law judge determinations. And that makes it a very difficult, steep hill to climb, especially if you have dollar amounts in appeal above certain levels or claims exceeding a certain number, because then they have to divide those cases up between 2 or 3 judges, and they may not all be in the same region. They may not all have the same philosophy, and they may not all care the same way. I literally had a judge, and I don't know, Robert, if this was a case I did with you or if it was with Amanda Wesh, but the judge came online, and before we could even say the very first word, he was irate. And he wanted to know why all of the claims that were submitted for this case were split up amongst other attorneys, and why he was now the third, between 3 judges, and why he was now the 3rd judge having to hear these claims, and the fact that there was an inconsistency in the rulings issued by the first 2 judges. So it put him into a hairy, situation where he's like, what am I going to do?
Yeah. Now, we've seen that situation, and the Office of Medicare Hearings and Appeals should have reconsolidated those claims into a single case and put it in front of a judge.
And that's what we tried to get done. And it was, listen, we've had some wonderful judges, and I don't want anybody thinking that I'm demeaning or talking down or talking badly about the Office of Medicare Hearing and Appeals. I'm not. Outside of one judge, I've had nothing but a phenomenal experience with OMA. I've done more than 300 administrative law judge appeals in almost, now 30 years of doing healthcare. And only one judge, and I think I talked to you about this judge. I mean, he just read me the freaking riot act and he actually told me, Mr. Weiss, this is going to be a woodshed moment.
Yeah. He's my new favorite judge.
Yeah. And I kept quiet. And this was a case with Amanda Wesh. Yeah. And Amanda was like feverishly texting me because she knows my mouth.
Yeah.
And she's like, do not respond, Sean. And I was like, okay, I will not summon my inner Donald Trump, which, by the way, I'm not a Trump fan. Let me just put that out there right now. I was just trying to bring some levity and humor to a non-funny situation. But the really interesting thing in here, God's honest truth, you ask Amanda Wesh, that same day after he just abused us like redheaded stepchildren on that call, his administrative assistant called Amanda and told her that she was formally apologizing for what transpired on that call, and that the judge asked her to advise us that we received a wholly favorable finding. I mean, somebody must have peed in his Wheaties or something, because this guy was just off the rails.
Well, I will say this. They have been under an enormous amount of stress,
yes,
and pressure to fix a problem that was not their cause.
Mm-hmm.
They didn't cause a problem, but these judges that are there now have inherited it for a decade, and they had to fix it in the last 6 months. But it's interesting to me, while you're right, the cases that you file today will be heard within 90 days, and they will get those decisions out within the time period permitted. But all they've really done is kick the can down the road, because now everything's being held up when you have to appeal it at the appeals council.
Mm-hmm.
Or you're asking for it to be remanded back to the judge for reconsideration. And people don't realize that you can actually send something back to a judge to ask them to reconsider their decision before you file to a DAB.
Ashley, you just did that, didn't you?
Megan did, yes.
Okay.
Yeah, another attorney.
Yeah.
But yeah, and I've seen the council too has been just remanding cases. Like they'll find any reason to get rid of it back to the ALJ because they're overwhelmed now. Any technical thing, they're like, we remand it back to.
And if you're wondering what I did to get the verbal boot from that judge, I was off by 1 digit on my citation for the Medicare Program Integrity Manual. I literally was trying to cite Chapter 3, 3.1.1.1, and I said 3.2.1.1. And he was like, I'm looking for that citation, Mr. Weiss, and I can't find it. I'm like, oh my gosh, Your Honor, I am so sorry. Verbatim. I'm like, oh my gosh, Your Honor, I am so sorry. It's 3.1.1.1. And oh my God, he's like, your client's paying you to be the expert. How dare you make a mistake? And I'm like, have you never made a mistake in your life, Your Honor? And Amanda was like, no, do not say that. But it turned out okay at the very end.
Regardless of if you have complaints about the current process, we're going to look back on these days and we're going to say those were the good old days, because wait till you have to go through all of these processes with the Advantage plans. Mm-hmm. Sean, it's just a nightmare.
Oh, it sucks. That's the only way to say it. It sucks. But let me ask you this question. This will be my final question that I'll pose, and I'll tell you the reason why in a second. Do you believe that bots will be eventually replacing the administrative law judges and the attorney adjudicators at OMA? And here's the reason why I ask.
No, I don't believe so.
Okay. Well, here's the reason why I asked. ChatGPT, their AI bot, actually put out a statement that they will be able to do the job better than more than 4.3 million workers right now. And one of them was in writing. Writing. There was an incredible article, and I was like, holy crap. And then, if you don't think AI is dangerous, let me tell you something. AI, actually, there's a case right now where AI reprimanded a person. The ChatGPT bot reprimanded a person. I was like, you got to be kidding me. This stuff is dangerous. And if you want to go back and watch a movie for a guy who I'm not a big fan of, Will Smith, I, Robot, that started the whole AI conversation, man. And we are there. All right. Last word, Robert, Ashley, anything?
No, I would just reiterate, if you get a request for records from a UPIC, take it seriously and act like every level is the only level you've got, because you got to put your best foot forward from the very beginning.
I agree.
Ashley? Oh,
no, I mean, Robert pretty much summarized it. I mean, you have to take these things seriously. Make sure you understand what the coverage requirements are at the outset, so you're in a better place. But if you do get a request from a UPIC, you need to take it seriously, act timely, reach out to counsel to make sure that you're putting your best foot forward.
And here's the thing, the most critical aspect of everything that both of you have said in these closing statements is you've got to be proactive. Don't wait until you've already filed appeals on your own and you've screwed everything up to go and get somebody who actually knows what they're doing, because it will cost you a lot more money and you probably will have jeopardized your case by not hiring somebody with the legal skills and acumen needed to be able to navigate the muddy waters, of the appeal system.
That's right.
Yeah, that's right.
All right. This is quickly becoming one of my favorite segments to do. You guys are fantastic.
Thank you, Sean. It's
fun
chatting with you.
Absolutely. All right. That's going to do it for this episode of The Compliance Guy, Legal with Liles and Parker. I want to again thank my very good friends Ashley Morgan and Robert Liles for joining me today on this program. And again, to each and every single one of you, thank you so much for tuning in, logging on, and just hanging out with us for a little while. I'll be back next Monday with a brand new Coding and Compliance Roundtable with our distinguished panel of characters: Scott Kraft, Stephanie Auer, Terry Fletcher, and Paul Spencer. So until then, have a blessed weekend, and remember, be good to yourself, but more importantly, y'all be good to each other. Take care.